according to the Supreme Court, disturbs the seniority of the judges. They want the approvals of who will become a judge to come in the same order as the recommendation. Let me explain this further. The latest face-off is about Advocate John Satyan. His name was recommended by the Collegium for elevation as judge to the Madras High Court in 2022. This recommendation was rejected by the centre. And in a departure from tradition, the Supreme Court made public the reasons for rejection. In this case, it was because Advocate Satyan had shared an article critical of Prime Minister Modi on social media and had reposted a news piece on a NEET aspirant committing suicide with a header that it was a political betrayal and a comment that said, "Shame on India." In response, the Supreme Court reiterated his recommendation in Jan this year, saying that these reasons do not impact his suitability to become a judge, as he has a good professional and personal image. The centre has not responded since then. The Supreme Court now says, approve Satyan before you approve the fresh list of 4 recommendations we've made, or the seniority of judges gets impacted. Now, the backdrop to this is an ongoing battle on how judges are appointed to the High Court and Supreme Court. The current system is a collegium system which comprises the CJI, that's the Chief Justice of India, and 4 senior-most judges. The centre has been trying to replace this with a panel that would include the government and civil society members. This attempt has already been rebuffed. The judiciary is now seeing the centre dragging its feet on approving the collegium's recommendations and in some cases rejecting them. The question now is, what is the way out of this logjam? In a country where nearly 70,000 cases are pending in the Supreme Court and over 60 lakh in high courts, judges' appointments are crucial to deliver speedy justice to citizens. To speak more on this, Colin Gonsalves, senior advocate in the Supreme Court, with me on the show. Karuna Nandi, advocate in the Supreme Court, also joining me. I'm speaking with Desh Ratan Nigam, lawyer, and shortly I'll be joined by Justice Satish Chandra, who's a retired judge. Welcome to all of you, and thank you so much for speaking with us this evening on Beyond the Headline. Mr. Gonsalves, let me begin with your take. You know, we know that this is an ongoing sort of flashpoint or a face-off between the centre and the judiciary, or the executive and the judiciary. In the latest developments, do you think that there is a message that the top court is trying to put out when it has talked specifically about the Advocate Satyan case?
This issue has been going on for a very long time. And I personally have been very disappointed to see how the central government bullied the judiciary again and again and again. And I was disappointed that the judiciary didn't stand up and say, once we give the names, once you send it back, once we reiterate the names, you are bound to appoint them. The judiciary didn't stand up for a long, long time, and we were very upset. But now it looks as if the judiciary is saying, enough is enough. When we give you the names in a certain order, you will accept them all, particularly when they are reiterated and it comes back to the government a second time. You have to take all the names. You have no business, in view of the Supreme Court judgments on this topic, to choose one and not the other, to choose the junior-most judge and leave out the senior-most, or to play around with that list in any manner. And I'm so happy to see the Supreme Court putting its foot down and saying, enough is enough. We follow the law, we give you the names, you appoint the judges. Unfortunately, we have a law minister who doesn't talk like a law minister at all. And his rough language, his insulting language, his bullying language gives an indication that this is not just coming from him, it's coming right from the Prime Minister himself, that he has freedom to scold and criticize and say things about judges which are unheard of. To call retired Supreme Court judges anti-national is the crudest possible attack on the judiciary. It's not the language of an erudite person. It's not the reasonable language of a minister. And it disentitles him from being the law minister of this country. And as a lawyer, I'm ashamed that we have a law minister of this caliber.
You know, what you're saying, Mr. Gonsalves, I think is reflecting how polarized the views have become as far as the judiciary's role and the executive's role are. And whatever side you may be on, that's not good news for the functioning of this democracy. I want to get Desh Ratan Nigam in on some of the comments that have been made. Do you think that the message coming in from the Supreme Court today is, as Mr. Gonsalves says, enough is enough?
Agree with that. Absolutely not. The fact is, government is making it clear that enough is enough. We have a system out here where the original position of the Constitution that the executive would appoint after consultation with the Supreme Court Chief Justice. That was the original position. And I agree that's the position of law, that the judgment is already there. But government is now asserting that the elected representative who are accountable to the people must take control of the situation. Now, this collegium system we all know is opaque, non-transparent. We have seen nepotism also, and completely there is no accountability. Independence of judiciary is maintained by removing them, making their removal very difficult through a process of parliament, and that is how independence of judiciary is maintained. Now, let me also point out, one of the judges, let me make it very clear, Justice K.M. Joseph bypassed 38 judges during his time when he was appointed without giving any reasons. And ultimately, the accountability has to be fixed in the system. The people who actually appoint have to be made accountable. And how do you do that in a democracy? In a democracy, people who appoint go to the people, and if they have made a bad choice or a bad decision, people will punish them through electoral process. But here, what is the accountability if you appoint somebody bad? And let me tell you.
So, 1 minute, Mr. Nigam, I want to understand. I want to understand.
No,
so
let me finish first.
Sure. No, just one point, and then you can continue, please. Just one point, please, and then you can continue. You said that this is not the way of accountability. Would the accountability mean, or would the government saying enough is enough, like you're saying, mean that they just sit on recommendations?
Let me tell you, we have a system of check and balances. Absolute power cannot be given to anybody, whether it is the government, whether it is the judiciary. Judiciary cannot appoint its own self. They cannot be a judge in their own cause. First, you decide these are the names. Then you say we'll pass a judgment over it. That's not how democracy functions. If Supreme Court is given an absolute power of appointment over judges or to perform legislative functions, that would be the end of democracy in India. And let me also point out, there is a very serious question. Our president has a pocket veto. Can anybody supersede that pocket veto? No, nobody can. Even Supreme Court cannot supersede that pocket veto. So a president can sit over the recommendations for as many time as he wants. So the question arises, is Supreme Court having absolute power to appoint or not, even with the existence of the judgment of the collegium system? Because president, through the system of check and balances, has that check and balance power of a pocket veto. So these are very serious questions which need to be answered.
No, these are definitely serious questions, which is why we're taking up, and we think they deserve to, be discussed and explained. For some of our viewers, they might be wondering, why are we talking about this? It seems like a dry subject, but this really pertains to how our democracy functions and where the check and balance is. Karuna Nandi, what is your response to the argument of check and balance? Desh Ratan Nigam says there should be a check and balance. No one can argue against that. There should be a check and balance for each and everyone. Why not for the judiciary?
The system of checks and balances is precisely why every single viewer of this show should care deeply about the system of appointment of judges. The government is the biggest litigant before the court. At the moment, the system of checks and balances essentially is that the executive or the government will administer the country in various ways. Parliament will make laws, and the judiciary will keep a check on are those laws constitutional? Is the government functioning in a way that is constitutional and is according to law that Parliament makes? So this is how the system works, right? Once you have the government starting to appoint the judges that they want, you have a problem. This is what is currently being sought to be done, right? And I think it's a mistake to say that what Mr. Gonsalves is saying is polarizing, because what he is saying is actually the current constitutional position. And I suspect the reason that he's so exercised about this is that the government is failing to follow the current constitutional position. Now, whatever that is, we must be very clear that there must, in this country, be rule of law. This is a constitutional democracy. This is not a democracy where if, the government decides that 100 people, like I saw in your show that later on you're going to have a story about FIRs on people who are making political posters. That if the government decides to do that, and if the appointment of the judge is entirely dependent on the government, what kind of independence are you going to have? Am I saying that the collegium system is perfect? Absolutely not. Kenya, South Africa, and the United States have a system where you have the names are made public prior to the appointment. Now, what happens is that prevents a situation like the Justice Victoria Gowrie situation, which is that the name has gone to the IB and the IB has come back with, essentially nothing, and the lady has been appointed. Now, if that name had been made public, the collegium would not have been caught unawares. They would have known that not only is she a member of the BJP Mahila Morcha or the president, but that she had made certain kinds of speech, and let your viewers decide whether that was hate speech or not. Right?
No, so you're saying there should be you're saying there should be a referendum on every judge or every recommendation?
No, I am not saying that.
Someone has to take a call, right?
Absolutely. But what I am saying is that there are moves towards transparency by the collegium. An additional move can be that you make the names public before the appointment. There are, the Chief Justice said recently that a number of young people are just not taking up judgeship, and it's because this kind of tussle, which is against the Constitution, against every tenet of discipline in this constitutional democracy, is, making it very difficult for people to be willing to have their names put forward. And so in such a situation, I think that the collegium is already taking moves towards transparency. Better moves can be made. There are other jurisdictions we can look to.
Okay, so to recap, so not everyone or not everyone agrees that the collegium is the right choice. Karuna Nandi says she's not saying the collegium is perfect, but what the government is doing is not correct either. Justice Chandra also with us now on the show. Justice Chandra, just to quickly bring you up to speed of what we've discussed so far, the latest move by the Supreme Court to talk about the Advocate Satyan case, the Advocate John Satyan case, seems like they're saying enough is enough. That was the view coming in from Colin Gonsalves. What do you think? Do you think now the Supreme Court needs to step in and make it clear that when we recommend a judge, you reject it, we reiterate it, then you should go ahead and appoint the judges? Isn't it worrying that we are in this logjam?
Madam, in India, we have the largest democracy and the constitution is supreme. Article 124 and 217 of the constitution provides the provision for the appointment of the High Court judges and Supreme Court judges by the President with the consultation of the Chief Justice of India. But there is no word of the collegium. And this collegium was hijacked by this Supreme Court itself in the case of the Advocates on Record versus Union of India, 6th October 1993, where 9 judges bench and the writer was Justice Verma, who said now this will be the family matter. Executive has no role. So collegium has came into existence. And as earlier co-panelists said, no system is perfect. That is true. Earlier, before collegium, the executive was making the appointments and so many eminent jurists were there. Sitalwad and so many persons you will find. Earlier they were there, left 1 or 2 rotten eggs everywhere you will find. Now the collegium system is continuing, and this is there is one side effect of this one. I am not saying that every judge is not good, but position is this: dynasty is there. There is one judge in the Supreme Court presently whose family was having 7 judges. I am not saying that those judges were not on merit. there might be merit, but people are thinking, why from the one family, why not others? And when there is a collegium, you will
Nepotism.
find
Nepotism is a charge. Yes, nepotism is an important charge which has been made twice now on this show, and that perception is very much there. The perception is very much there, Colin Gonsalves. It can't be poo-pooed away. This is not one of those things where there is, no merit to the argument that there is lack of transparency. Just quick response from Colin Gonsalves, and then I'll come to you, Karunanand.
I'll come straight to the point. The battle is over perceptions of this kind. The judiciary wants independent people who are independent of the government. The government wants saffronized people. People with a saffron background, a BJP background, an RSS background, people who will not be independent when government cases come before them and will be compelled or feel compelled because of their allegiance to the central government. Allegiance. That will trump the constitutional consideration. They will be favorable to the government. That is what the Prime Minister wants. That is what the Law Minister wants. And what the judges are doing, they're pushing back. They say, no, you may be saffron, sometimes you may not be saffron. We want judges who, whether they are saffron or not, will be independent and be capable in appropriate cases to taking the judgment, to taking the government to task strongly. They don't want
that's a very strong charge.
person.
It's a very strong charge, Colin Gonsalves has made.
Independent. Why is the language used
Desh
by the
Ratan
law
Nigam,
minister
he's
so
saying this is
strong?
not about checks and balance. This is about getting favorable people into the judiciary. It's a very strong charge.
Well,
What
I know
he's saying are strong words,
Colin, let me answer.
If I may just...
I understand. No, the question is to me, please, madam. Please.
Why don't you finish first?
Yeah. So I know Colin Gonsalves' background in and out, so I don't want to comment personally on him. I know his political and ideological inclinations also. So let's answer on merits rather than saffronization or making it red or otherwise. Let's not go into red and orange here. So let me point out, the Supreme Court amended the Constitution. Can it do so? Can it substitute a system which was already given in a constitution and substituted by another system that is called amendment, that is a legislative domain? And that was done in Keshav Nanda Bharti's case, calling it a concept of a basic structure, which was given by 7:6 ratio, very thin, wafer thin majority. However, the government is now asserting the only bad period we saw in judiciary was during emergency time. Otherwise, the system was working perfectly fine, and there were people superseded, people were brought in. A lot of politics was done at that point of time. We have not seen that kind of period anywhere, either prior to emergency or after the emergency period, even till today. So these ideological, things that Mr. Gonsalves is trying to bring has no merit.
So Mr. Nigam, are you satisfied with the current system where the collegium proposes? Where the collegium proposes and the center does not respond?
See, the fact is the system needs to change. The collegium system has to go lock, stock and barrel. I'm very clear about that. Nepotism, everything, whatever you may do, this will remain. It is so non-transparent, opaque, without any accountability. How do you ensure accountability? How do you go against the basic doctrine?
Please respond. How do you ensure if the system is... Yes. Okay, please finish, Mr. Nigam, but complete that point and then, yeah.
See, the system that we have today, the collegium system would remain the way it is. You may bring minor changes here and there, but you need accountability. The first and foremost thing. And how can somebody appoint himself? Please tell me, this is not the judicial or principle of jurisprudence. Or you become a judge in your own cause. Every lawyer in this panel argues these two principles before the court. And we allow these two principles.
Can I get a counter now? If you've made your point, Desh Ratan Nigam says the collegium system needs to go lock, stock and barrel. How can you appoint yourself? Karunanandi.
I think the very vociferousness of Mr. Nigam is actually mirroring what the government's approach. If it goes lock, stock and barrel, then who is it that is going to judge the government? The government's appointee. Will they be judges in their own cause? Is it true that if you are in a particular system, that you will know better what the ins and outs are with regard to a particular lawyer or a particular judge who is to be appointed, that you are likely to know what their record is, you are likely to know better what their ability to decide a case according to constitutional values are. Now, the thing is that nothing can go lock, stock, and barrel. The whole point of our constitutional system is a system of checks and balances. With regard to the charge of nepotism, I am a first-generation lawyer, and I am a woman. And I would be the first to say that, and I have in many fora, that there just aren't enough women in the judiciary. The latest round of appointments had 7 men, right? However, let us look at the type of nepotism that you have in parliament. Let the BJP put a mirror before itself. Let us look at the type of nepotism that you have in government. And then let us remove nepotism from everywhere that it exists. Let us make sure that the kind, and I think there should be aspirational quotas in the judiciary where you say that we are going to try, and they should be public.
Okay.
That we are going to try to appoint
Ms. Nandi, just on the nepotism charge in Parliament, the counter argument would be those who make it to Parliament are elected by the people of this country. It's not just a small group of people deciding.
Those who make it to the Supreme Court go through a process where they have to pass bar exams. They then have to go to the High Court. There are IB reports on them. Government feeds in. Government is allowed one veto. They then have to have a particular record and particular seniority before they are then appointed. No system is perfect, Ms. Inamdar. Let us be clear about that. But let us be clear that if this imperfect system is dumped, we are going to be in the kind of dark era that we have never seen before.
All right. You can't let government decide who becomes a judge because at many points in time, the government is also in the dock. So what is the solution out of this logjam? Justice Chandra, surely you don't want a situation where there is no freedom of judiciary, but you also want transparency. What is the solution?
No. Government and judiciary both should make the appointments and recommend. That is why the Constitution provided that the executive, that means the president will make the appointment after consultation of the Chief Justice of India. So that is there already provision there. And the Supreme Court is to interpret the law and to lay down the law, but executive work is not there. And you have seen that so many judges are superseded. What they will do in their High Court? If they were superseded, they are demoralized. So this system is not working properly. It needs either improvement or abrogations.
Okay, so there is a very strong logjam as the views on this panel show. At the end of the day, all we would say is we need to find a way out as a democracy. It's not good for anyone if these two sides are not seeing eye to eye on something as crucial as the appointment of judges. I want to thank all of you. I'm out of time on this discussion, but stay tuned for what we're talking about after the break, because if you're taking a home loan right now, it's very, very important to you. Has